In 1803, the United States stood at a crossroads. John Marshall and his court had just issued their opinion in Marbury v. Madison, and with it, they had catapulted the Supreme Court from a relatively minor and unimportant branch of government into the ultimate overseer of every action by the federal government. However, the Supreme Court had, and still has, no enforcement ability. President Thomas Jefferson technically had no obligation to follow the court's order, both legally and in terms of precedent. So what happened? Why does the Supreme Court still count judicial review as one of its main powers, and why is John Marshall the most important Chief Justice in American history? Let's talk about it. Before we get any further into today's episode, I just want to quickly ask that you subscribe and like if you enjoy my content. It really helps the channel out and it motivates me to make more content. Now back to your regularly scheduled programming. Firstly, I should note here that if you have not seen the first episode in this mini-series, you should definitely hit pause on this episode and go back and check it out, as it provides much of the background for this case. The link will be in the upper right hand corner as well as in the description. Marbury v. Madison was not simply a case about appointing a judge. It carried, even before Marshall's decision, an extra sort of importance. As we've already discussed, the court at this point in American history was essentially powerless. Yes, it had decided a few cases, but when you compare the early court to, say, the early Congress, there is a massive power gap. So the first issue was that if the court did rule in favor of Marbury and granted him his writ of mandamus, what would happen if Jefferson and Madison simply ignored it? This would have been catastrophic for the court. If another branch of government was able to simply ignore the ruling of the court, then it would have lost what little bit of power it held, along with all of its legitimacy. The precedent of ignoring the court would have been set by one of the most important founding fathers, no less, and future administrations would have done the same. On the other hand, if the court ruled in favor of Madison and Jefferson and refused to grant Marbury his writ, then the court would have delivered a massive victory to the Democratic Republicans that followed Jefferson. Remember that at this point, Marshall and his fellow justices were all Federalist, and even though the court likes to paint itself as above politics, the justices are still human and cannot remove their own personal biases. So already, even before any deliberation had occurred, the court was in a tight spot. Marshall was able to solve this issue by essentially breaking the case into two separate parts. As we've already talked about, the court ruled that Marbury should have been entitled to his commission. This pleased the Federalists. But at the same time, Marshall ruled that the court was unable to grant a writ to force Madison to deliver the commission. This pleased Madison and Jefferson. However, Marshall had been looking for a case to introduce the idea of judicial review, and was able to effectively turn this case into such an opportunity. And think about it, this was too good of an opportunity to pass up. Firstly, with his ruling prior to establishing judicial review, Marshall had been able to at least placate both sides. He had given the Federalists the satisfaction of being able to say that under the current law, Marbury deserved his commission. But he'd also given Jefferson and his Democratic Republicans a victory in saying that ultimately the court was unable to issue any sort of writ for Marbury. In the same ruling, Marshall used the new judicial review power not to expand the power of the Supreme Court further, but to strike down a portion of law that had, at least on paper, expanded the jurisdiction of the court. So now Marshall had turned the tables on Jefferson, and it was now Jefferson who was in a bind. After all, Jefferson had got exactly what he wanted. Marbury would not be a judge, and the court had limited its own jurisdiction. How was Jefferson supposed to argue against that? Marshall's brilliance here cannot be understated. If this had been any other case, or if Marshall had left out any portion of the decision, then judicial review may very well have been challenged, and it may very well have not survived such a challenge. Even to this day, Marshall and his decision are subject to quite a bit of skepticism and general criticism. Firstly, the fact that Marshall had wanted to introduce judicial review for quite some time prior to this case gives the impression that Marshall was reaching for some way to rule in such a manner. This opens up a line of questioning about bias and credibility that we're not really going to get into. However, it is fair to say that Marshall was striving towards introducing judicial review, and the idea that he molded this decision into a carrier for that idea cannot be discounted, and in fact may very well be the truth. Secondly, Marshall could have just as easily avoided the constitutional questions in this case. He could have just as easily ruled that Marbury had no right to his commission until it was delivered, or that because Marbury's position was a political appointment, it could only be remedied through the political process, and thus the court had no power to intervene. This kind of ties in with the first, but it is fairly obvious that Marshall could have easily avoided the constitutional questions that he would eventually tackle in his last portion of the opinion. And lastly, and probably most importantly, the decision from Marshall is not based around logical reasonings from the Constitution itself. Marshall's opinion is really nothing more than a series of assertions that he draws from his own reading of the Constitution. Nowhere does it say that the court should be the final arbiter of constitutionality. The entire opinion was based around the way that Marshall himself interpreted the Constitution, not the text. In the end, however, it didn't matter. Jefferson and Madison were unwilling to challenge the case, and of course the Federalists were not going to challenge such a case. Thus, the precedent was set, and the Supreme Court had gained the power of judicial review. And after McCulloch versus Maryland, just about 16 years later, the Supreme Court's status as the ultimate interpreter of the Constitution would be cemented. It would actually be another 50 years before the court ultimately struck down another federal law. That case, Dred Scott v. Sanford, would go on to be viewed as one of the court's worst decisions. But cases from U.S. v. Nixon, to Loving v. Virginia, to Citizens United, all used judicial review in some way, and without it, the court would have never turned into what it is today. Our story, though, doesn't end here. While we are discussing Marbury versus Madison, we may as well discuss John Marshall himself. Marshall is truly the father of the modern Supreme Court. Not only did he introduce the idea of judicial review, but in the same way George Washington molded the office of the president into what it is today, Marshall did the same with the office of Chief Justice. Prior to Marshall, the court delivered opinions from each justice individually. This is helpful in getting to see exactly what each justice is thinking, or believed in. But it was not quite so helpful in developing precedent, nor giving a clear and understandable reading of the case. So Marshall began the practice of writing a single majority ruling, thus allowing the court to present a clear rule and set a clear precedent. While we may not put so much stock into this today, we should remember that we have some 200 years of precedent from our courts. During Marshall's time, the court was a fledgling institution that borrowed nearly all of its precedent, rules, practices, and so on from English common law. Marshall's newly created majority opinions gave the court a way to create its own precedent and practices. Marshall was also able to work well with his other justices, who were actually lawyers unlike Marshall himself. He would often tell Joseph's story, for instance, their story. That is the law of this case, now go find the authorities. However, Marshall also worked well with William Johnson and Bushrod, sick name by the way, Washington. Together, these men would quite literally form the court into an authoritative, respectable, and co-equal branch of government. Marshall was also a strategic genius. We've already seen some of this genius in his ability to turn the tables on Jefferson and Madison and Marbury, but we should also remember that Marshall did not use the power of judicial review for the rest of his term. Now, I might hear you asking, well, why does that mean anything? Doesn't that just give the other branches an opportunity to write off judicial review as a one-time thing? Well, normally you would be right. Typically in government, using a power over and over again is the way to make sure that that power is baked into whatever position or institution it's coming from. But here, we are not only talking about the government, but also the law. In not using judicial review, Marshall was also giving his opponents and those who did not believe in judicial review no opportunity to challenge it. With no opportunity to challenge it, the idea of judicial review continued to exist as part of the precedent of American constitutional law. And the longer that it survived as precedent, the harder it was to get rid of. Marshall also knew the power of the majority. His opinions would hold much more authority and be much more likely to go unchallenged if he could get the entirety, or as much as possible, of the rest of the court to back him. Because of this, Marshall only ever found himself in the minority on one case, Ogden v. Saunders. He would even moderate his own views just to be able to have more members of the court sign on to his opinions, and thus give those opinions more authority and legitimacy. John Marshall inherited a position as Chief Justice that held little to no actual power. The position oversaw a court that was so unimportant it didn't even have its own building. The Constitution gave little powers to the court explicitly, and the first Chief Justice was so frustrated by the lack of power that he literally resigned to run for governor. Yet when John Marshall left his office, the Supreme Court was a prestigious, authoritative, and co-equal branch of government. It was the ultimate oversight authority, and a court that every aspiring lawyer or judge dreamed of being on one day. For better or for worse, it was John Marshall who turned the Supreme Court into what it is today, and without him, the court would have remained powerless. Thank you for watching. I hope you enjoyed it, and I hope you learned something. I would love to make this series based around suggestions from you all. So if you have any suggestions or want me to cover a certain topic, comment them down below. Those topics can be anything, from our ancient ancestors like Australopithecus to the history of World War II. If you have any further comments or questions on the video, or believe I've made a mistake, please comment down below. And please like and subscribe if you enjoyed. It really helps the channel out. Peace.